Hello everyone, and thank you for joining me for January 2019 My PIP Monthly. My name is Javon David and I'm a partner at Secrest Wardle. As we do every month, we'll go through some case law here today, and then we'll talk about a trending topic in PIP litigation. I've got a few cases for you in the case law update, some pertaining to fraud and then the other pertaining to arbitration and agreements to arbitrate. The trending topic in PIP litigation this month seems to be solicitation. Some judges are seemingly more inclined to rule on the solicitation arguments that we've always made under the NoFault Act. So I think it's a good idea to just have a refresher as to what the law is in that regard. So the first case we've got to discuss this month is Newman versus Suburban Mobility Authority for Regional Transportation, also known as Smart Bus Company. In that case, the plaintiff filed suit seeking PIP benefits from defendant Smart as a result of injury sustained on a bus that he was on in July of 2013. The parties ultimately submitted the case to a binding arbitration and signed an agreement to arbitrate that stated the benefits and award applied to all past, present, and future PIP claims, known or unknown, claimed or unclaimed. Ultimately, the arbitration panel awarded plaintiff $50,000, and the award stated that it was for past and present injuries only. The award did not mention any future benefits or any future claims. Several years later, the plaintiff again filed suit against the same defendant seeking past, present, and future PIP benefits. Defendant moved for summary disposition, arguing that the case was barred by the arbitration agreement as well as the doctrine of res judicata. The trial court granted defendant's motion for summary disposition, holding that the arbitration agreement, which stated that all past, present, and future PIP claims would be arbitrated, was controlling. The plaintiff disagreed and appealed the decision of the trial court. Again, on appeal, the plaintiff made the same arguments that he did at the trial court level, essentially relying on Douglas versus Allstate and the assertion that, as a matter of law, there is no claim for future benefits because claims for no-fault benefits must be incurred. So what they tried to do, it seems, is akin this to a jury verdict on a PIP case, where the award is through the date of the verdict. So the Court of Appeals had to essentially look at whether or not the terms of the agreement to arbitrate would be enforced or if the award as written would be enforced. In addition, the Court of Appeals did a nice analysis of Douglas versus Allstate and whether plaintiff was correct for their assertion that they could not have possibly, signed off on future benefits because the benefits have to be incurred. Ultimately, the Court of Appeals affirmed the trial court's ruling. And in reaching its decision, the court examined what's called the Uniform Arbitration Act, which you may or may not know governs all of our arbitrations that we go into on any of these cases, and including no-fault cases. And the court ultimately held that the same legal principles that govern contract interpretation also apply to the interpretation of arbitration agreements. So the arbitration agreement constitutes the law of the case, and the arbiters are bound to follow the guidelines set forth in the four corners of that document. So the scope of the arbitration is determined by the agreement, and the arbitration agreement determines the scope of the award, even if the award does not explicitly state that it applies to everything listed in the arbitration agreement. Ultimately, the Court of Appeals held that the trial court got it right when it ruled in favor of the defendants and determined that even though the award itself did not mention any language regarding release of future benefits, the parties agreed to that and entered into the arbitration agreement knowing that they would be releasing future benefits. So the lesson to be had here is to avoid this kind of long procedural drawn-out process where you'll end up in the Court of Appeals on this kind of issue, is to raise the issue if it comes up at arbitration. If you notice that your award is different from your agreement to arbitrate because, for example, like in this case, it did not include an award for future benefits, then ask the arbiters to clarify that and to ask them to either amend the language of their award or work with counsel in that regard. Another option to secure your basis is typically you'll have to do a release after an arbitration, and in there you'll put pursuant to the terms of the agreement to arbitrate, and you can reiterate those release terms as well. But ultimately, regardless of whether or not you have those abilities and options going forward, the agreement to arbitrate is going to be key. And you are going to rely on that language when trying to enforce a later or enforce the arbitration agreement down the line. Just as in here, the plaintiff tried to file a lawsuit, but they were clearly barred by their agreement to arbitrate that they had entered into in their first generation lawsuit. So the takeaway from this case is that the arbitration agreement governs the arbitration award even when the award contradicts the agreement itself. Lots of lessons to be learned from the Newman case, especially dealing with, procedurally how you go about the award and working to ensure that it's pretty consistent. Now, the next case is Edwards versus Progressive, which is a suit that was handled by our law firm, by our lawyers, Javon Williams, and our appellate attorney, Sydney Klinger. In the case of Edwards, the plaintiff filed a combined PIP and third-party action in Genesee County Circuit Court, alleging serious and permanent injuries stemming from the accident. Ultimately, the trial court was presented with evidence that plaintiff was the sole owner of the vehicle, yet failed to procure the requisite insurance for her vehicle as mandated by the NoFault Act. In response, the plaintiff argued that she was entitled to recover no-fault benefits as well as non-economic benefits because her non-resident boyfriend was an owner who also insured the vehicle. The trial court agreed with defendant insurer and dismissed plaintiff's lawsuit in its entirety. The plaintiff then appealed. The primary question before the appellate panel was whether the trial court erred in finding that plaintiff's boyfriend was not an owner of the vehicle so as to allow plaintiff to recover damages in her lawsuit and benefits from Progressive. The Court of Appeals ultimately affirmed the trial court's ruling, disagreeing with plaintiff's argument that her boyfriend was an owner because he had unlimited access to the vehicle. Specifically, the court adopted the insurer's definition of the owner as set forth by the NoFault Act over plaintiff's request that the court use the Motor Vehicle Code's definition of owner. In doing so, the court articulated that plaintiff's boyfriend did not use the vehicle in ways that comported with concepts of ownership. For example, there was no evidence of proprietary or possessory usage. Such sporadic or temporary use, such as borrowing a vehicle, does not bring one within the NoFault Act definition of owner. So ultimately, the court held that because the plaintiff owner failed to insure her vehicle that she was operating at the time of the accident, she was barred from receiving no-fault benefits pursuant to the NoFault Act, and that she was similarly barred from recovering non-economic damages as a result. Now, what's important about this case is not only the facts and the procedure and the law regarding ownership, which we're all familiar with and we encounter quite frequently on these kinds of cases, but also note that the plaintiff attorney tried to deviate from what the NoFault Act prescribes as a definition of owner. And the Court of Appeals correctly says when you're dealing with the statute, you look to the statute first. If the statute defines an owner, that is what it's applied. And that's exactly what was applied in this case. We argued, meaning Secrest Wardle, that the NoFault Act does define owner, and therefore plaintiff's own definition of what an owner means should not apply to this case. And the Court of Appeals agreed with our position in that regard. Now, the last case that we're going to talk about today is Parker versus Farmers Insurance Company. This is interesting because there was another case that came down from the court. It's the Emerson file, or the Emerson case that came out the day before that basically went through, Emanuel, not Emerson, Emanuel versus Allstate, and it came out about a few days before this one. And they both address what it means under 3173 to commit a fraudulent insurance act. So in this particular case, the Court of Appeals clarified what constitute a fraudulent insurance act for no-fault insurance claims submitted to the Michigan Automobile Insurance Placement Facility, or the MAIPF. The Court of Appeals upheld the trial court's decision to deny the plaintiff's entire claim for no-fault benefits based on the submission of fraudulent attendant care forms. So just by way of background in the Parker case, plaintiff was involved in two separate accidents, one in October 2015 and the other in November 2015. he submitted a claim to the MAIPF as both accidents involved his brother's uninsured vehicle. The claim was ultimately assigned to Farmers Insurance Exchange, which is the defendant in this lawsuit. To support his claim, the plaintiff submitted multiple attendant care forms indicating that plaintiff received 24-hour care from the date of the first accident back in October of 2015 and onward. These services were allegedly provided by his mother and girlfriend, and these forms were signed by plaintiff and his mother and included care on the days when plaintiff was involved in the second accident. Defendant Farmers later discovered that plaintiff's mother was instructed by an attendant care provider agency to backdate the forms to the date of the first accident, even though she did not actually provide any care until after the second accident. Both plaintiff and his mother testified that care was not provided as depicted on the forms, and the mother admitted she knew she was providing false information to defendant Farmers. Ultimately, defendant Farmers stopped paying the no-fault claim after learning that the forms were untrue, and that they were also backdated. And obviously, the following suit ensued. Now, what's key to this case and applicable to our other cases, if you handle MAIPF claims, is what the definition of Fraudulent Insurance Act means. And the court looked to the definition set forth in 3172 as it pertains to fraud, but also looked to other case law such as the Chandler versus Farm Bureau case in support of its ruling. Just briefly, I'll go through what 3173 provides. 3173, for those of you who don't regularly handle MAIPF cases, is the provision of the NoFault Act that governs claims submitted to the Michigan Automobile Insurance Placement Facility, also known as the MAIPF. And the statute provides its own definition of fraud because obviously the claims submitted to the MAIPF aren't subject to any policy terms. So typically in a claim that you would handle, you would be able to file a BOCRI motion, you'd be able to look to the terms of the policy with regard to fraud. There's no policy in place in MAIPF cases, so the statute itself is what you would rely on if you're analyzing this kind of case. So, what does 31737 say? It says the following: a person who presents or causes to be presented an oral or written statement, including computer-generated information, as part of or in support of a claim to the Michigan Automobile Insurance Placement Facility for payment or another benefit, knowing that the statement contains false information concerning a fact or thing material to the claim, commits a fraudulent insurance act that is subject to the penalties imposed under 500.4511. Now, a claim that contains or is supported by a fraudulent insurance act, as described in the subsection, is ineligible for payment of benefits through the assigned claims plan. Now, that particular provision just tells us that you would have to argue that the person committed a quote-unquote fraudulent insurance act. Since there's no specific definition as to what that means in the statute, you can look to the case law that interprets what that means. And a fraudulent insurance act has been defined by the courts as an oral or written statement presented in support of a claim for no-fault benefits to the MAIPF by a person who knew the statement contained false information and the statement concerned a fact material to the claim. The case that you can rely on in that regard, I've cited here on the slides for you, is the Chandler versus Farm Bureau case, which nicely sets forth what the standards should be. Now, plaintiff in this particular case did not contest that the other elements of fraudulent insurance acts were not met. The court rejected plaintiff's argument that only his attendant care claim should be barred and he should be eligible for other no-fault benefits. This argument was specifically addressed in the Chandler court and determined that a claim under 3173 meant a claim for benefits generally and not for a claim for some benefits and not others. Ultimately, the Court of Appeals confirmed that the trial court's order granting summary disposition in Farmer's favor and the ruling completely barred plaintiff from receiving any benefits from the assigned claims facility or the MAIPF. So what's key about this case is that when you're determining a fraud situation or assessing a fraudulent case in claims involving the MAIPF, let's say you're the assigned carrier, such as Farm Bureau or Farmers was here, you're going to look to both 3173 and case law regarding fraudulent insurance acts. And this is just, the Chandler case is just one that of many that kind of go through what that means and how they can be applied to your claims. These kinds of things can get a little tricky. So, I mean, if you have any questions, of course, feel free to reach out to anyone in our office, but any counsel that you're working with should be able to walk you through what it means to commit a fraudulent insurance act if you're dealing with an MAIPF claim. All right, so those are the main cases that came down from the Court of Appeals today that would be applicable to your claim handling. And now we'll talk a bit about trending topics in PIP litigation. As stated, it seems like the solicitation arguments are getting further and further in the courts. Initially, it was almost like the courts didn't really know how to handle them on PIP cases, and so they would deny the case or take it under advisement and do that whole song and dance. We've had success more recently in the courts with the solicitation arguments, and so I just want to do a little refresher for those of you handling these claims that may or may not involve fraud, or that if you suspect fraud or if you suspect some sort of solicitation, on what you should be looking for in those kinds of claims. So when you're dealing with a potential solicitation, meaning the provider had reached out to the plaintiff, before, with close in time to the accident, and the treatment seems pretty guided by the providers themselves, you can do this type of analysis to see if you have an argument to be made. So under Michigan law, solicitation is its own definition. And the meaning of solicitation under the statute is 750.410 is as follows. A person shall not intentionally contact any individual that the person knows has sustained a personal injury as a direct result of a motor vehicle accident, or an immediate family member of that individual, with a direct solicitation to provide a service until the expiration of 30 days after the date of the motor vehicle accident. So this provides for, it's against the law, basically, for an attorney or a provider to reach out to someone within 30 days of an accident and try to get them to sign up with a nurse case manager or a facility or a transportation facility, or even if they're in their own law firm. You have to give the person 30 days after the date of the motor vehicle accident. And I'm sure we've all seen in claims where the plaintiff says, well, I was in the hospital and someone came up to my bed and signed me up with this nurse case management service, and then my treatment kind of started from there. That would be in violation of 750.410. Now, the pertinent provision under the NoFault Act deals with 3157, and this is how you're going to tie it into the solicitation statute of 750.410. Now, the NoFault Act specifically provides that a physician, hospital, clinic, or other person or institution lawfully rendering treatment to an injured person for an accidental bodily injury covered by personal protection insurance. So basically, the NoFault Act says that we're only responsible for lawfully rendered treatment. So what does the argument become? The argument becomes that since the provider, or even the attorney, but usually the provider, did not lawfully render treatment because they approached the plaintiff, they guided this kind of treatment, and they solicited them for their treatment, it's not compensable under the NoFault Act because it was not lawfully rendered. In other words, the provider committed an unlawful act that precludes their bills from getting paid under the NoFault Act because the treatment is not lawfully rendered. So, having that background and understanding the interplay between the two statutes, what do you have to do in your claim handling? Well, when you suspect that the provider treatment is largely some part of a solicitation ring, or if you think that the plaintiff themselves was particularly solicited in this action, then you can utilize both 750.410 and the NoFault Act to further investigate the claim and kind of set it up so that you can, if it gets to litigation, you can move for dismissal, or you can, work in assessing whether or not the claim is compensable based on the solicitation. So how do you do that? From the claims perspective, you will likely want to secure some sort of testimony or sworn statements. If you suspect that a lot of the treatment is provider driven, the claimant calls you and says, hey, I'm trying to make an insurance claim, but someone showed up to my hospital or someone showed up to my house and gave me this card and told me to start treating, then you'll want to secure testimony or sworn statements either by EUO or some sort of affidavit from this person. Hopefully they'll be able to give you very specific information early on about which provider solicited them or the name of the person, or they can maybe give you a photocopy of the card. And once you have that information, it makes it easier to ascertain where the solicitation stems from. Now, that allows you to investigate the provider involvement, maybe even the attorney involvement. But what's so important here is that you're asking these questions pre-litigation. Oftentimes, by the time the plaintiff files a lawsuit, if and when they do, if solicitation was something that occurred pre-suit or around the time of the accident, the adjuster is going to be the first to know about it, or should be the first to know about it. Because by the time the deposition happens nearly a year or so later, the plaintiff or the claimant may not be able to remember the key details as to who solicited them. They might say, someone came to my house, but I don't remember their name. I don't really remember what they looked like. They gave me a card, but I can't find it. You'll get all of these kinds of excuses in their testimony. So from the claims perspective, you can prevent a lot of these issues if you ask the right questions pre-litigation. If you're talking to the claimant and they mention that someone came to their house unsolicited or uninvited and started setting them up for treatment, get every specific detail that you can about it, log it in your log notes, and ask them to provide you copies of the person's card, their business information, or anything that they can provide, and let them know that that is legal to do. So those are things that can happen up front that will protect the claim and will protect the entirety of the lawsuit going forward. So if you have any more questions, please feel free to contact me. My contact information is in the last slide. For those of you listening on the go, again, this is Javon David. I'm a partner at Secrest Wardle, and I welcome your questions and comments. Thank you.